I'm Ed Hoffman. I'm the association attorney. I think
So
the what you should all understand as unit owners is absent these changes being adopted, and it takes 67% of the entire membership to do that pursuant to the statute. That means 67%, 2/3 supermajority of your whole community has to say yes to pass these amendments. Absent that occurring, and Brian made reference to this earlier, and he made Ryan the kind of the jackbooted thug of the of the endeavor here. But joking aside, the board and or association is going to be required to enforce the covenants as they stand. So if you don't like what you see currently, then you presumably should vote to change them to loosen up the I guess the draconian nature of some of the requirements that are present. Um, and unless you get the votes, they're going to have to start enforcing it. And then what happens is owners will say, well, why are you enforcing this? It's ridiculous. Or I already have this out here. I already have a screen door that doesn't comply. Well, right. But because the documents provide for it, the association is going to have to enforce it. That being said, the option to vote to change it is here. And that's why the board's proposing this. And you have this informational meeting now, and then you'll have the vote occurring in May, right? May, what is it? May 16th. So that's kind of where you are. Not sugarcoating it here. I'm telling you exactly what's happening. That's really the reason why we're here today and why they're doing what they're doing more than anything else online. The issue isn't necessarily if you can't have it or not. The issue is what documents currently provide for is what this is what I got back to before is what the association is going to have to enforce. So if you don't like it, you should probably vote to change it. It's giving you actually more leeway. I'm not here to sell anything, yes or no to you, but these amendments are all basically to allow you to have more flexibility in what you're doing to your own homes rather than what the developer, declarant K, provided to you in the original set of documents that were drafted and recorded with the county. So, and by the way, how this would all work, and maybe you don't know that, is the impetus of this is to have the owners vote 67% to change the declaration. Once that change would be made, then we would put together a recordable form submission to submit to the recorder of deeds office. That would then get recorded, and then that would apply to all your properties in the community. So then the current or the amended declaration would apply. And that's the whole exercise here, is to amend what you have, what the developer saddled you with, to allow you to do things that make a little more sense and dare I say common sense issues. And that's really where you're going to go with this.
being being a homeowner, being on the home board association, and also being a realtor, I can vouch for that. That once you buy a house or a resale, MRH provides you with every piece of paper, including bylaws, the dues, everything else to the seller, the paperwork to the seller and the paperwork to the buyer. They both have to sign that they acknowledge that they read it and they got it. So it's up to them now whether they want to go through and read it or not, but they have it. It's their choice.